Welcome everyone to our event, CRS seminar. It's great to be joined here in person by all of you and all of you online. Feel free to introduce yourselves in the chat if you like. And we have a wonderful speaker here. Kohki, when he was introduced to me by Michelle, I was told he is a rock star in Japan. But I think he's a rock star everywhere. And he's become a rock star here at CRS. And this is a super exciting talk. Not just because it pulls on his expertise, but also because I think it's some of the things that he's been musing about. Many of the conversations that we've been having as a collective here at CRS about nation building and nation shrinking. And he's also come to Canada at a very interesting time, having visited twice previously as former CRS visitor. He's come back again now, and at a time where Canada is, I don't know, strange?
Strange, yeah.
Right? Like, I think it's hard to put words to what exactly the feeling is in our country right now and our place in the world and in the new or current world order. So for you to be engaging with these topics at a time where Canada seems like in flux, and our refugee and immigration concerns and policies are at a crossroads. They can really go in varying directions. And also, ones that might honor our history of multiculturalism, right? Or ones that might go against it, as the threat from the South keeps asking us to steal our border and secure our border, whatever those words mean, our 8,100-kilometer border with the US.
Yeah.
So that's my informal bio of Kohki. So now I'll read the official formal one. Kohki is a visiting scholar at CRS and professor of international law and peace studies at Meiji Gakuin University in Japan. Past president of Japanese Society of International Human Rights Law, Peace Studies Association in Japan, and Human Rights Now, a Japanese-based international NGO. See, rockstar. He also served as a refugee examination counselor for the Minister of Justice for 10 years, from 2012 to 2022. Currently, he's the co-representative of Refugee Studies Japan and executive council member of Japan branch of the Asian Society of International Law. He has many seminal pieces of work in Japanese, which I will not cite, and in English, which I will also cite. It's too long, too many books of importance. So thank you, Kohki, for being with us. Next, we have a great discussion. Professor Idil Atak, thank you so much for joining. When I asked Kohki for suggestions, your name came up, and you're the only person. No, there was nobody else. It just had to be. So I'm so glad that when we emailed you, you said yes. Professor Atak is a professor at the Lincoln Alexander School of Law. Before joining CMU, Atak worked as a legal expert in Turkish foreign ministry and as a deputy to the permanent representative of Turkey. To the Council of Europe. Professor Atak earned her PhD in University of Montreal, Faculty of Law, and was a Schurk postdoctoral fellow at McGill University's Center of Human Rights and Legal Pluralism. She currently serves as a director at large of the Canadian Association of Refugee and Forced Migration Studies, and is a member of the International Association for the Study of Forced Migration's Executive Committee and a past president of the CARPS. She served as editor-in-chief of the International Journal of Migration and Border Studies from 2017 to 2020. Thank you so much for joining us. And please, only hard questions. Okay? Scholar at the top of his game, you should be able to handle anything from any of us, including those of us who are online. So please, as you listen to his brilliant presentation, come up with some really hard questions. No softballs. Take it away, Kohki.
Okay, thank you. Thank you, Yvonne, for the kind introduction. And Professor Atak, thank you for coming to make comments on my talk, and thank you everybody for coming to my talk. And I see familiar faces in person and virtually. There are many people joining. I very much appreciate your participation. Now let me first share my PowerPoint slide. Okay, I just wonder if anyone can see my PowerPoint slide. No, is there any problem? No?
Good. Okay.
Okay. It's always a problem at the beginning.
You need to go back or?
No. I don't need this part. Is it?
Oh, I see. All your beautiful pictures or faces are taking up Professor Abe's screen, so he's trying to move you out of the way. That's what we're troubleshooting right now.
Very good. Okay, thank you so much. Well, I've been in the Center for Refugee Studies this time for 6 months, and in my stay in Canada, I have been profoundly affected, influenced by the political refugee and migration studies that work in Canada, and particularly the indigenous perspectives. As the Christina Clark-Kazak says, the understandings of post-migration cannot be separated from indigenous worldviews, epistemologies, and lived experiences. Well, this phrase is really appealing to me because I have been committed to the third world approaches to international law. As an international lawyer, the colonial responsibility is a big issue for me to address. And I find the close relations with the indigenous perspectives and international decolonial project. That's why I found the indigenous perspectives in the Canada so interesting and I should say attractive. Well, as you see, the Canada is generally known as a nation of immigrants, and it's a nation that is an attractive destination for new immigrants. This is the nationalist ideology and also the contemporary nation-building narrative. But the flip side of this statement is the settler colonialism. Very ugly face of settler colonialism appears on the flip side of the robust nationalist ideology or the contemporary nation-building narrative. You see, the more immigration, the more the indigenous people eradicated from their own territories. And toward the end of 20th century, the big project of settler colonialism has virtually come to an end, with almost all the indigenous people being eradicated from their own territories. And then with it came the Canadian ethnic identity and strong patriotism. So Canadian nationalist ideology and narratives have been successful in producing a Canadian ethnic identity and cultivating patriotism. And this has been amplified these days with the strong pressure from south of the borders. With the threat from the United States, we see the swelling of Canadianism. So it's a kind of strong patriotism and also nurturing the Canadian ethnic identity. One famous law professor, Catherine Duverny, who used to teach at the British Columbia University Law School, says that Canada is now at the nation-maintaining stage from the nation-building stage. And it's now in Canada, the immigration is locked into a nation-sustaining model. And the goals are just to fill in gaps rather than welcoming people to enrich Canada, but just to fill in the gaps. This is how Canada maintains itself. And with this, in this maintaining stage, they try to develop a strong and cohesive Canadian society. And you see a lot of aversions, very strong aversion to irregularity and fear of threats, dangers to society. At the nation maintaining stage, aversion to irregularity and fear of threats are very commonly seen. And that's happening in Canada. You may wonder the refugee issue or refugee protection is different from immigration issues or immigration in general, because refugees is protected in international law and it's within the special regime for protection. But actually, as Professor Atak clearly says, the refugee admission is also is considered to shape the boundaries of national membership. It's not been disconnected with the immigration scheme. And as Professor Jim Hathaway, who is the guru of the world refugee law community, actually endorses Professor Atak's view that refugee law in Canada has evolved as an outgrowth of the traditional policy of promoting immigration. So refugee is also within the framework of the immigration. Now, with that framework, broader framework in mind, let's see a trajectory of refugee protection in Canada very briefly. Canada joined the Refugee Convention regime in 1969. Well, actually, it was 18 years after the adoption of the Refugee Convention. And in 1976, Canada, for the first time, introduced the Refugee Determination procedure through the Immigration Act. And through this act, not only inland asylum procedures, but also resettlement scheme was legislated. And as everybody knows, the private sponsorship program is something Canada should be most proud of. And this was introduced through by the Immigration Act of 1976. With regard to inland asylum protection, actually there are many problems and deficiencies in the procedures that was introduced in 1976. Particularly, the lack of oral hearings by the decision maker was decisively wrong, decisively deficient. In the 1980s, Canada, for the first time, adopted the human rights part of the Constitution. The Canadian Charter of Rights and Freedoms was enacted in 1982. And under this charter, the Supreme Court of Canada rendered a landmark decision, Sin decision, in 1985, which harshly criticized the refugee protection procedure in Canada in place in those days, and particularly from the perspective of fundamental justice. In the same year, Gunther Club published a commission report titled Refugee Determination in Canada, which presented a broader framework for reform. Then the government responded by establishing the new agency for determining the refugee status. That is the Immigration and Refugee Board of Canada. The abbreviation is ILB. This is world renowned. It's a global icon of refugee protection. No other agency in the world actually stuck up against the ILB in terms of protection of refugees, even now. In 1986, people of Canada awarded the Nansen Medal in recognition of their major and sustained contribution to the cause of refugees. And in 1993, the Supreme Court of Canada rendered another world-famous decision, Ward decision, Canada versus Ward, which effectively helped expand the scope of interpretation of the definition of the term refugee. Probably this was the heyday of Canada's refugee protection, particularly with regard to the inland protection. And it was the days of multiculturalism setting in. In the 1980s, a trend underway in the 1970s became even more pronounced. This saw the arrival of increasing number of newcomers from Asia and other non-European areas. So the heyday was in the days of multiculturalism in Canada eventually set in. Unfortunately, since then, the subsequent developments were not something to be celebrated. One commentator says that subsequent developments reflect and produce a culture of gatekeeping and disbelief within refugee status decision-making in Canada. Through a series of legislative schemes and administrative schemes, the space for protection, inland protection in Canada has shrinked. And with the latest one being the 2027, let's say it's a global campaign to warn newcomers, don't come to Canada for protection. Actually, it's titled "Coming Asylum in Canada is Not Easy." So in a nutshell, since the establishment of ILB until today, what we see may be summarized as the following. First is externalization of border control or asylum elsewhere policy. This is don't come to Canada. Canada, asylum seekers are prevented from coming to Canada. And Canada has a special agreement with the United States, safe third country agreement. And visa imposition, visa requirements, and carrier sanctions, etc., are all for the asylum elsewhere policies. And even if you come to Canada for protection, then the hurdles are waiting for you. That is the institutional barriers to seek asylum. Before reaching ILB, Immigration and Refugee Board, you have to go through border agencies assessment. That is the inadmissibility scheme on security violation of human or international rights, serious criminality, or organized criminality grounds by the Canada Border Service Agency and Immigration, Refugees, and Citizenship Canada. So it's very difficult. It's getting difficult to reach the world-renowned ILB for protection. And even if you reach the ILB, there are many, many problems occurring. Refugee status determination actually is not serving for the protection, but as a means of denying protection. And as Sean Rihag, the Osgoode Hall Law School professor, refers to the current system as the luck of the draw. And or Peter Schauer says it's a refugee roulette, meaning that everything depends upon who you are, who are the decision makers. If you are lucky, then you may be recognized. If you're not, then you are denied. This may be, let's say, be seen in the stage of credibility assessment. And credibility assessment in ILB is not consistent. And it shows a Eurocentric mindset, and particularly with regard to the sexual minority applicants, the inconsistency in credibility assessment and Eurocentric mindset appears. And also in ILB, they set a higher standard of proof. When you prove some facts, you have to prove on a higher standard of proof. That is the balance of probability, which means the probability that something actually happened is over 50%. So you have to prove over 50.1% that something actually happened, which is a really high standard to prove some facts. And very little use of international human rights norms is another deficient aspect of the practice of Immigration and Refugee Board. And other than refugee determination, you see some particular groups are being detained automatically and for indefinite detention, for indefinite period. They are detained foreign nationals. This is clearly a discriminatory treatment against international standards. What is really disconcerting these days is that asylum seekers who come to Canada are pitted against the resettlement refugees. The discourse goes that refugees, if they are abroad, they are genuine. They are true refugees, deserving protection. But if they once come to Canada, they are illegals. on their borders. So refugees in Canada simply disappear. It's what is called the discussing disappearance of the refugee. This is a phrase from the Audrey MacLean, who is the professor at the University of Toronto. So this is all happening at the stage of nation building, at the stage of nation maintaining from the nation building. But still, if you take a step back and look at Canada from abroad, Canada's record is brilliant. Canada's refugee recognition rate remains #1 in the world. That's because ILBs are still remaining committed to the protection of refugees, and there's a strong advocacy by progressive citizens and professionals and scholars like Professor Atak. And also occasionally you have very well-informed judicial decisions and vision of Canada as a country to welcome refugees still alive. This is behind the fact that Canada still remains the world-renowned country for protection of refugees. Actually, Japan cannot compare with Canada at all. If you look at this chart, sorry for using Japanese partly, but if the Canada is the 5th bar from the left, this is the record of 2023. 39,735 applications were made, 35 cases were granted. So almost 40,000 refugees were granted in Canada in 2023. And recognition rate was 68.4%. Almost all of them, all of the applications were actually granted. And the record is much better in the next year, 2024. And this is absolute #1 record in the world. And if you compare Canada with Japan, Japan is the far right. I don't like the term far right, so let me use the term the end of the right end. 303 people were recognized as refugees in 2023, and the recognition rate was merely 3.8. Canada, 68.4%, and Japan, 3.8%. It's a huge difference. But for Japan, for people working in Japan, 303 and 3.8, they're record number, record-breaking numbers. If you look at this chart, the achievements of the applications and granted cases, the orange bar implies the number of applications, and it's been gradually growing. And then came the COVID, and now again surge. Where is the brown bar? If you, I will allow all of you to use the microscope this time and focus the right hand. You see very, very short brown bar. 2023, 303 was, if you look at this chart, is record-breaking. Although it's a very small, but it's something we never expected. You may have questions about which countries are actually represented among the applicants. In 2023, 87 countries were represented, and top 5 countries included Sri Lanka, Turkey, and Pakistan, and the like. Out of 303 recognized refugees in that same year, the vast majority were from Afghanistan and Myanmar, implying some political or diplomatic consideration in this record. Why has Japan been so cold or cold-hearted to refugees? Probably to think about this issue, you have to look at the post-war national ideology of Japan. It's an ethnically homogeneous nation. Prior to the Second World War, Japan was a multi-ethnic nation because it was empire. So occupying the East Asia and Southeast Asia, it inevitably was a multi-ethnic nation. But after the end of Second World War, the discourse of homogeneous nation came in, and it was strongly held and promoted by the government. Indeed, it was a myth. It was an ideology. Japan has been always multi-ethnic. But after the Second World War, the dominant discourse promoted by the government was the homogeneous nation. And that ideology or myth has been maintained by strict immigration control and non-acceptance of immigrants and refugees and judicial passivity. Judicial has never intervened in the situations to transform the society, just like Canada. Japanese judges have been always passive and deferred to the decisions of the administration. And these three pillars are based on the broader social ethos, that is groupism or conformism. And harmony or deference to the authority is something we have been forced to be instilled into our minds through the education or in the social settings. And citizens' engagement for human rights and minorities inevitably have been very, very weak. The foundation of Japan's post-war immigration system is firstly in 1951 immigration control order, and more importantly in 1978 the Supreme Court of Japan rendered a decision which is still alive, in which the Supreme Court says that if you don't have legal status in Japan, you're rightless. So undocumented or irregular foreigners in Japan are judicially rightless, which has been firmly endorsed by the Supreme Court. And they are subjected to indefinite detention, or even if provisionally released, they are subjected to inhuman or degrading treatment in lack of any legal protection. In 1970s, toward the end of 1970s or 80s, the wave of internationalization came to Japan, and into 90s and 21st century, then globalization wave came to Japan. And with it, there was some changes actually taking place. The first catalyst for change was the arrival of Indo-Chinese refugees in 1978. In that year, Japan accepted 3 refugees, only 3, but it was the beginning of the subsequent stories. Eventually, Japan accepted more than 10,000 Indo-Chinese refugees. In 1979, Japan ratified the International Covenants on Human Rights. These treaties, International Covenants on Human Rights, are actually the most important human rights treaties, and it was the beginning for Japan to be part of the international human rights regime. In 1981, Japan acceded to the Refugee Convention and its protocol, 30 years after its adoption. Now Japan is now part of the international refugee regime. In 1920s and in the 21st century, Japan gradually developed into the stage of transition to a multicultural society. It's not I should say, ideologically multicultural society, but empirically multicultural society, because of corporate demand and aging society and lack of labor force, and also the increase in international marriage. These elements also pushed Japan to be in the transition to at least the empirically multicultural society. But still, it's on condition that the border is strictly controlled. But this transition had some impact on refugee admission and protection. As we saw in the year 2023, we saw a record-breaking number of more than 300 recognized refugees. This is partly because of the transition to multicultural society. Now, let's see how the refugee protection has been actually handled in Japan. When Japan acceded to the Refugee Convention, it was because of the diplomatic pressure, strong diplomatic and political pressure from the US. And with the accession to the Refugee Convention, Japan, for the first time, enacted the legislation providing for the refugee recognition procedures. That was to implement the Refugee Convention and protocol. But the government declared in those days that we don't have an intention to immediately open the door for asylum. The basic structure of the refugee recognition procedure in those days was quite bad. There were two-stage procedures. The first instance, application was made to the regional immigration bureaus, and refugee inquirers did the interview, and opinions were formed and forwarded to the Justice Minister for decision. And the negative decision is made, and if you're not satisfied, you may appeal. The second stage starts with the appeal to the regional immigration bureaus, and refugee inquirers do the interview, and the opinions are formed and forwarded to the Justice Minister for decision. As you see, it's a repetition of the first stage. It's a fundamentally deficient. The biggest problem was all the procedure was conducted within the framework of the border control agency. There was no independence of procedure, and lack of oral hearings by decision makers is another deficient point. And these are actually problems that Canada experienced in the 1970s. In 2005, the Immigration Act was revised, and for the first time there was a reform, a major reform, actually introduced in the refugee recognition procedure in Japan. The refugee examination counselor system was introduced in appeal stage. However, quite unlike Canada, actually Canada made a fundamental change with the ILB being introduced in 1988 and 1989. But Japan's reform was, to say the most, incremental and gradual. And the new structure for refugee determination procedure seems almost the same, but the minor difference being in the second instance stage. The appeal to regional immigration bureau is made, then not refugee inquirers, but newly established system, refugee examination counselor system works here. Refugee examination counselor is considered independent, but otherwise the whole procedure is the same. The fundamental problem remains lack of institutional independence from enforcement agencies. Because there's no independence from the enforcement agencies, the institutional culture remains as a gatekeeper to protect borders rather than to protect refugees. Even the refugee examination counselors, who are supposed to be independent, infused by this institutional culture and served as part of gatekeepers. So refugee determination procedure was actually remains a sovereign act or discretionary act to protect national borders. This was the result of 2005 reform. But as I pointed out, the internationalization and globalization waves came. Newly emerging circumstances took place in 2010s or subsequent to the 2010 year, the year of 2010. There was an increase in the number of asylum applicants, an increase in the number of pending cases, and the decision-making process was prolonged. Yes, the government was actually pressured to change the refugee protection system. The response of the government was not for the protection, for reinforcement of the protection of refugees, but protection of national borders. So enforcement and deportation was reinforced in compensation for an uptick in refugee acceptance and for fortress multicultural Japan. So we're increasingly receiving refugees, but always under the fortress and multicultural framework. Fundamental problems of refugee status determination remain. Refugee status determination is even now conducted within an enforcement agency. And the principle of detention of foreigners without legal status remains as ever. As we saw, the foreigners without legal status, they are actually rightless, effectively endorsed by the Supreme Court. A deeply ingrained thought in Japan's immigration and refugee legislation remains: we can do whatever we please with foreigners. This is a statement made by a high-ranking official of the Ministry of Justice in the 1960s, but still this mentality is vividly alive and permeates the immigration and refugee law in Japan. Foreigners without legal status is in absolute legal limbo, and sovereign discretion should dictate policies on immigration and refugees, because we can do whatever we please with foreigners, including refugees. I cannot end my small talk with the negative remarks. Let me show some transformative developments on the horizon. Increasingly, we see impressive challenges by lawyers, practicing lawyers and citizens, and they have come to produce some very positive results from otherwise very passive judiciary. It started with 2022 Sapporo High Court judgment. This is the first time that the asylum applicants from Turkey, the Kurdish asylum applicants, was recognized as refugee. And in March in 2023, the Osaka District Court judgment also was quite outstanding in the sense that it was the first case of a sexual minority claiming persecution in their home country being granted refugee status in Japan through a judicial decision. And last year in May, the Nagoya District Court judgment was also very interesting because it was the first time that the court has ordered the government to revoke the negative decision and grant refugee status to a Syrian national. And one recent decision refers to the Chinese claimants. The Chinese claimants, it's very difficult in Japan for asylum applications from China to be granted. But through these judgments, Chinese claimants are also given refugee status. So Chinese, Syrians, Kurds, and asylum applicants fearing the persecution based on sexualities are gradually being given by refugee status through these kinds of judicial judgments. This is a silver lining, and it's mainly due to the, let's say, tenacious activities of the committed lawyers and concerned citizens. These judgments show the outstanding credibility assessment, and cardinal principle of refugee protection is finally taken into consideration in judgments. But still, we have a lot of tasks ahead for human rights-based refugee status determination. Above all, we need an independent agency to determine refugee status, just like Canada has Immigration and Refugee Board, independent agency for protecting refugee status for refugees. As Gunther Prout says in his commission work published in 1985, that led to the fundamental reformation of Canada's refugee protection system. The determination whether or not a person is a refugee must be made by an independent body. It should not be within the border agency. And we need comprehensive legislation against all forms of discrimination. Canada has one. And we need to establish independent national human rights machineries. Canada has federal and provincial human rights commissions. So comprehensive human rights act and independent national human rights machinery is something Japan lacks. And we need to have access to individual complaints mechanisms under the human rights treaties. These are some of the tasks ahead to bring about the human rights-based protection for refugees in Japan. And when we think about what we should do in Japan, I always think about what Canada is doing. And indeed, Canada's role in international society is huge. And it has made positive impacts on other countries, particularly Japan. And I think this is a critical moment, and it's a good moment for Canadians to reflect upon what makes Canada really Canadian. And for outside scholars like me, Canada is a special country, particularly for immigration and refugee protection. And I hope Canadians should use this critical moment to facilitate decolonization process, not only within Canada, but beyond national borders. And also, I hope the Canadians will deepen the humanitarian and compassionate spirits, receiving a lot of pressure from the United States. People are forced to think about what is Canada, what makes Canada really Canadian. And the very core, very basis of Canada is the humanitarian and compassionate spirits. I really hope the Canadians should utilize this opportunity to deepen the humanitarian and compassionate spirits, because Canada's role in the international society is huge, and it will have really positive impact on what we do in Japan. Well, thank you so much for my small talk. Okay.
Thank you so much, Professor Abe, for this presentation. It's so rich. You provided a brief but also an in-depth overview of not only the Canadian Refugee Status Determination system, but also Japan's. And you offered a comparative perspective for us to understand the similarities, but also the differences. And I also appreciate the forward-looking conclusion and recommendations for Canada moving forward. I have several takeaways. It's such a rich presentation. I will touch upon 3 of them. I really appreciated the fact that you started with the importance of network. And I feel the same. I am really very grateful of being part of the network of the Center for Refugee Studies. It's been several years, decades now. I'm part of it, and it really makes a huge difference. It's a network of researchers, students, scholars, practitioners, but also policymakers and implementers. And we get together and we learn from each other. It's so important, critical for critical knowledge production and dissemination. And I was also thinking that CRS plays the role of secretariat for important Canadian but international associations on forced migration. So thank you for emphasizing the role of networking. I totally share your point of view. And then decolonization and indigenous perspectives is another thing that you emphasize. I agree with you. We have more and more research and researchers working on the intersections between indigenous justice and forced migration or immigration-related justice issues. And this is expanding, and this is a really positive development. I think moving forward, more and more research should be conducted on how to decolonize policies, but also research, resource dissemination. My third takeaway, it's not about Canada, but it's more about Turkey. This is my country of origin, and I was thinking as you were speaking of some parallels between Japan and Turkey in terms of this national ethos you mentioned. How after the Second World War, Japan was seen itself as an ethnically homogeneous society and nation, and how it shaped its understanding of refugee and immigration policies as well. I see some parallels between Turkey and because I practiced practiced in a previous life as a civil servant, and I firsthand experienced how it was difficult for Turkish officials to overcome, to break barriers in terms of accepting the others, non-citizens, especially immigrants and refugees. Things have started to change when Turkey has become a transit country and a destination country for forced migrants. But especially, and it speaks to the last part of your presentation, when Turkey joined the European Court of Human Rights and started to be condemned by the court over and over again on its treatment of refugees and other non-citizens. So the international human rights law played a really important role for Turkey to change its policies and to become a little bit more protective of the human rights of everyone under its jurisdiction. Of course, when you look at the situation in the country now, you realize how a real commitment to the rule of law, democracy, and ethical leadership is also important in terms of continuing protection of especially non-citizens, but everyone under the jurisdiction of a state. And lastly, I really liked what your analysis of communal and refugee status determination. You emphasized the strengths of the system. And yesterday in my refugee law class, I had a representative from the IRB, Immigration and Refugee Board, and Refugee Protection Division. They mentioned that exactly the improvements we made in terms of decision training of the members of the Immigration and Refugee Board, guidelines by the IRB chairperson in terms of sexual orientation, gender identity, protection of minor refugees, claimants in Canada, etc., etc. And so they also said that 90% of claimants at the refugee protection are represented by counsel, which is it speaks to the strengths of the system. 65% acceptance rates at the RPD is also a good news for refugee claims. But at the same time, as you perfectly illustrated, we're not immune to bias in decision making. We're not immune to regressive policies like border securitization we're experiencing right now. Externalization is a real thing that's happening and preventing a lot of claimants from reaching the right of appeal is denied to a series of claimants. So you did really an excellent job illustrating the strengths of the system, but also the challenges for refugee claimants. Thank you for that. And I would finish my comments by asking a question. You mentioned Canada's role moving forward, that we are a respected member of the international community, and given our strengths in the refugee status determination, but also in terms of resettlement, we can be a role model. I'm wondering what you think about the current developments, especially in the US. President Trump questioning rules-based order, international law regarding refugee protection, how do you see, or do you think there will be an impact on Japan, refugee status determination, this new geopolitical, especially messages, negative messages, internal refugees?
Okay.
Yeah, go ahead.
Okay.
And we'll stop the recording after you answer.
Okay. Thank you so much, Professor Atak, for your comments. But I particularly appreciate you referring to the Turkey, your country, the previous country, in the same situation as we are in Japan, and also the important roles played by council representing the asylum applicants. It's over 90% in Canada. That's really impressive. In Japan, it's probably less than 10%. When I worked as a refugee examination counselor, I seldom encountered applicants represented by the council, 1 or 2%, or less than at least 5%. So having the qualified council making a really significant difference in decision making. That's something we should do in Japan. Thank you for your advice. Then your question, the U.S. impact on Japan immigration, probably refugee protection. Well, as far as I understand, we cannot see any immediate impact from the U.S. the current policies on Japan's refugee systems. Probably Canada is directly affected, but still Canada tries to protect itself from U.S. influence by confirming what makes Canada really Canadian. Humanitarian spirit is something that makes Canada really Canadian. Many people are thinking about this in Canada, and that is a direct influence of Trump's, administration's very weird policy making. But although Japan is very close to the United States, probably much closer to U.S. than Canada, and actually, well, this is quite joking, but Trump says that Canada should be 51st state of the United States. And if the Japanese government hears that statement, they should be angry because it's not Canada. It should be Japan. It should be the 51st state, and Canada should be 52nd. Well, to that extent, Japanese government feels very much, let's say, closeness with the United States. So diplomatic attitudes may be directly affected by the Trump's policies, but when it comes to the refugee system, I think, as I mentioned before, the judiciary is gradually changing based on the idea of refugee convention, and at least systematically, the judiciary is an independent institution in Japan from the administration. And we have increasing number of people engaged in the refugee protection, lawyers and citizens and scholars. We are constructing a sort of strong community for the protection of refugees. And judiciary decisions are partly affected by this, citizens' movement. So as far as I understand, the Trump's policies on refugee and immigration will not be directly affecting the Japan's policies, at least in the meantime. But if you extend the time span much further, the entire world may be affected in terms of the reception of immigrants and refugees. And if the entire world is affected, Japan may not escape. So in the long term, I don't know. But at least in the short term, Japan, this is part of my wish or hope. Japan will gradually further develop the domestic procedures for the protection of refugees without the Trump's very weird policies for refugees.
You can stop the recording now so we can ask people for questions.